let's just talk about what the risk of non-compliance look like. This is one of the main questions we're getting. Who enforces these rules and who is actually checking that we're complying with them? Are individuals able to complain, or can actions only be taken by a government, for example? Well, for those of you who have an EU background or experience with EU regulatory regimes, you won't be surprised that there'll be regulators in every EU member state, every EU country. They'll be charged with monitoring compliance with the rules. Looking at, things like GDPR, we are expecting regulators to utilize AI to audit in-scope digital services with high web traffic. And that's something we actually saw in the last couple of years from data protection regulators in the EU who were checking the top 100 websites, for example, for compliance with cookie and privacy laws. So it's definitely a tool available to them, and we do think it's something that they will use for enforcement. If a regulator were to find non-compliance, we typically expect, and in line with what we see with other regulatory regimes in the EU, a regulator would cooperate with you to remediate those issues and to address them before taking further action. We do tend to find regulators, as long as you engage with them and communicate with them, they tend to be relatively understanding, not all the time, but some of the time. If there was a finding of non-compliance and perhaps you didn't communicate with the regulator or you didn't want to make those changes that were non-compliant, the regulator would then have various tools available to it as set out in local laws. Typically, that would take the form of a fine, but in any event, the penalty needs to be effective, proportionate, and dissuasive. And again, this language is something we see across a lot of EU legislation, including the GDPR. But the EAA doesn't specifically set out what will actually happen if you don't comply. It's left up to member states to determine this. And going back to my point earlier about diverging standards, the fact that the EAA is supposed to make everything harmonized, we're already seeing really different approaches between member states in their respective stances against non-compliance. So taking Ireland, for example, probably the most extreme example we've seen, certain non-compliance can result in fines of up to 60,000 euros, so relatively low for a regulatory fine. But in quite extreme, specific examples and circumstances where there's been repeated non-compliance, this could actually result in prison sentences. Whereas in some other jurisdictions, and I'll give you a couple of examples, we're seeing things like GDPR levels of fines being introduced. So a percentage of your annual global turnover, for example, with no criminal liability. So there's already this really diverging exercise we're seeing taking place on how each member state is going to enforce the rules and take action against those that don't comply. So from doing some research online and with other clients, some countries, France, for example, have penalties for non-compliance of up to 250,000 euros, but others, Belgium, for example, from our research, fines can be limited only at maximum 50,000 euros. Sweden, we've seen examples of up to 200,000 euros. So there are massive discrepancies, and that's why it's so important to make sure that you have correctly assessed which country's rules you need to comply with, because if it is one with criminal sanctions, that's obviously going to be something you want to brief your board of directors on, for example. In terms of that criminal sanctions enforcement tool that the Irish regulator will have, we have been working closely with colleagues and other legal professionals in Ireland who are of the opinion that the sanctions, the criminal and prison sanctions will not be used by regulators, but that obviously isn't a promise that is to be found anywhere in a legal text. It's more informal commentary by the intended regulator. So definitely exercise caution when it comes to whether or not a particular regulator will exercise particular powers, because we just don't know yet how this will play out, given that the enforcement dates are not in effect yet. You may notice it's very different to US landscapes, where we tend to see class actions or private lawsuits. As you might have guessed from the last couple of minutes, in the EU landscape, accessibility compliance will be very largely and heavily regulator charged, which again is very similar to the regimes we see for data protection compliance.